Hi, Charles from Novak Migration over here. Today about PR refusal and what to do next. Information provided in this video is not a migration advice. If you need one, please book a consultation with migration agent. And information is based on the legislation current as of February 2019. Let's get to the case. Mike, I am currently on a bridging visa 010, which is bridging visa A. As my permanent residency was rejected due to failure of my immigration agent to provide the department the genuine need for my position, and further, he did not send an organizational chart or that the business is expanding or diversifying. We appealed the decision with the AAT short after the refusal. My question is, what happens if my current employer would go into administration? How can I move over to another company that would be willing to sponsor me again? If your business is going into administration, I wouldn't blame migration agent entirely, because there would be something more than just the organizational chart and some of the other stuff you are mentioning over here. But let's get to the bottom of the case. How can you move over to another company that would be willing to sponsor me again? Let's make some assumptions. I don't know which visa have you had before you have applied for the permanent residency, and you didn't mention which visa you applied for. But if an employer has been involved, probably that was ENS or RSMS. And let's assume you have had 457 visa with the same employer. So you had 457, then the same employer nominated you for the permanent residency, ENS or RSMS. It has been refused. Then you have appealed the decision with the AAT short after the refusal. Again, what was refused? Nomination and visa, or just the visa? If there was the failure to provide the department a genuine for my position, again, probably the nomination has been refused as well. So nomination has been refused and the visa has been refused as well. We appealed the decision with the AAT short after the refusal. So you have had to appeal the nomination. Make sure that you have appealed the visa application as well, because your visa was refused short after the nomination refusal. So if you want to keep your bridging visa A, make sure that your visa refusal has been appealed as well. Okay, so if there is another company who would be willing to sponsor you, you cannot apply for another visa while you are in Australia. There is something called Section 48 bar, which precludes people from applying for another visa while they are where they are on the bridging visa, when they don't have the substantial visa, when they are on the bridging visa, and their visa they applied for has been refused. So being subject to Section 48 bar, you cannot apply for another visa essentially in Australia. You would have to leave the country and apply for the visa overseas. With your current company, if the employer is going into administration, I don't see any chance that you will win in the AAT. As part of the application, the employer must prove to the department that the position will be available for at least 2 years after the visa grant. If they are going into administration, there is no way they can convince the case officer that your visa will be available, your position will be available for at least 2 years after the visa grant. Okay. If you found this information useful, please share it or like it to show your appreciation and give us the motivation to continue recording new material. If you want to have a chance to get your visa-related question answered, fill this form, novakmigration.com.au/contact us. If you need a migration advice, you can book it here, novakmigration.com.au/booking. There is a fee for consultation. Don't forget to subscribe to our channel. Thanks for watching and see you soon.